Good morning, and thank you so much for joining us here on Right Now. I am Chris Gros. Today is June 30th, and we have a huge amount of news to get to today, and it starts with a live look here at the White House as we are awaiting for a reaction from President Donald Trump, as we just learned within, I believe it was just about an hour ago, maybe a little bit more, that the Supreme Court officially struck down his challenge to birthright citizenship, something that was an executive order signed on day one, Jack. We had an entire show yesterday previewing this potential decision. We got the decision at the very end of the justices' term here as they are about to go into recess. It's a very busy morning. A lot of decisions were made.
Yeah.
This one in particular had a lot of eyeballs on it, obviously, because of the nature of it, the implications, the potential impact if it went the other way. Now we get to look at the impact of it going this way and what it means for the future, as well as how it is that the past influenced, obviously, so much of this. So just an incredible news day, if you will.
Yeah, it was being described as one of the most consequential rulings either which way, whether it was upholding the concept of birthright citizenship or overturning the concept of birthright citizenship. It was described as one of the biggest cases in regards to immigration and, of course, citizenship in over a century. The last time that we saw this concept really be challenged in the Supreme Court, which was something that we mentioned yesterday, was in the mid-1800s. So it has been a very long time since we have seen this thing, this concept of birthright citizenship, be relitigated in front of the High Court with mass consequences as to how many people here in the United States would be U.S. citizens, would not be U.S. citizens, how that would affect illegal immigration as a whole, undocumented immigrant populations here in the United States, because we'll get into some of these numbers of what this executive order that, like you mentioned, President Trump signed on his first day in office, what those effects could have been had it actually gone into effect. Of course, a lot of those numbers now are rendered moot because of this ruling, but nonetheless, it goes to underscore the vast reach that, if this were to be affirmed by the Supreme Court, which of course it wasn't, mass effects, mass consequences here throughout the country.
Yeah, and even in the way that the justices, so look, let's. So a lot of people want to know what like the scoreboard was, right? Like how is it that the justices ruled? Obviously, you only need a simple majority, right? This was technically a 6-3 decision. However, when you go through the justices, there is one who actually ruled sort of both in the opinion with Chief Justice John Roberts, but then also in the dissent, that being Justice Brett Kavanaugh. So really you sort of have a 5.5, 4.5, 3.5 ruling, because Justice Kavanaugh really did teeter on both sides of this argument. And again, regardless how he would have ruled, it would have been a 5-4 decision or a 6-3 decision. Again, the actual results don't matter. It's just if a decision is made, right?
Yeah. A lot of it, though, does kind of get into the head of it kind of helps dictate some of the reactions that we saw.
A lot of people want to know if this was going to be a 9-0 decision. This would have really affirmed the court's decision. But the fact that it was, I still think the 6-3 doesn't really do justice when you read the opinions, the dissents, and so forth. This was not as clear cut as what a 6-3 would lead you to believe. I think is fair to say. Yeah. We'll explain Kavanaugh a little bit later in the show, obviously, but I do just want to bring that context there of 6-3. But by far, was this a 6-3 decision by any means? I would say.
Yeah,
your normal one.
Yeah, and we were talking about both the arguments for birthright citizenship and against birthright citizenship. One of the things that we were talking about when it came to the arguments in favor was precedent. We talked about a Supreme Court ruling 160 years ago. We talked about legislation in the 1940s that used the same verbiage as we saw in the 14th Amendment. We'll get to that here in just a second. So if throughout this whole entire process you were someone who was advocating for birthright citizenship, you really did have a lot to point to, especially in the context of what's called originalism. That is the viewpoint of the Constitution where you interpret it as the framers intended it to be. coincidentally enough, that's often the same ideology, the same viewpoint when it comes to judicial review that you see a lot of these Supreme Court justices utilize. We'll go to some sound bites between those oral arguments, kind of highlighting that conversation and kind of the contrast between the Supreme Court justices and the government, the Solicitor General in particular, what that looks like. But yeah, I mean, we'll let's just get into it. How about that?
Yeah, let's just get into it.
It'll help explain it. We're going to do a bit of a recap of what we were talking about yesterday before we really start to dive into the opinions themselves, because we want to make sure if you weren't able to listen to yesterday's show where we broke it all down, you are for the most part caught up. So this, the lawsuit, the executive order, both of this really comes down to the 14th Amendment itself, which was ratified after the Civil War, specifically the Citizenship Clause, which is Section 1 of the 14th Amendment. It reads here, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside in. To kind of break it down to a more layman's terms sentiment, just means if you are born in the United States, you are an American. Now, that's something that has been disputed. We'll get into this other argument here in just a second, but we have, text and we have documentation of the debates leading up to the ratification of this that definitely helped the Supreme Court justices, at least the majority of them, get to the decision that they made. We talked about a quote from Senator Jacob Howard in the 1866 debates. He said here, quote, simply declaratory of the law of the land already that every person born within the limits of the United States is by virtue of natural law and national law a citizen. John Conness, in those as well, he declared that, quote, the children of all parentage should be regarded and treated as citizens of the United States, entitled to equal civil rights with other citizens. This for the majority of U.S. history, even as it had been challenged in the high court later on, was for the most part virtually, it was the wide consensus that this was the case. Now, we have polling that says that this is still a consensus, but in the advent of President Trump, his first term, his second term, there has been this movement that has sought for stricter immigration laws, stricter immigration policies, and as an offshoot of that sentiment, there was a call to reinterpret perhaps what this concept of birthright citizenship meant.
Yeah, because the idea is that, again, this was the 14th Amendment. 14th Amendment was done post-Civil War. Obviously, the Dred Scott decision that was a very controversial one and one that is obviously still asked about these days as sort of a litmus test when it comes to justices. Sort of a way to try to reverse that. You then had the second Supreme Court case that sort of reaffirmed the 14th Amendment, and then it was codified in the 1940s. But opponents to birthright citizenship are trying to say that this was merely a way to deal with the Dred Scott decision, that the 14th Amendment was never intended to apply to the children of immigrants, and that the things that we see happen now these days, that in the 1860s, planes did not exist. It was not so easy for people to come to the United States of America, and therefore they've created this tactic or this belief that there is a industry based upon birthright citizenship or tourism, a birth tourism industry.
Yeah.
I don't know why I've been saying the term all day, but I can't for whatever reason.
We've had a very hectic morning, so.
But just the idea that people are coming here solely to have children,
You also hear
so
the
that they
term-
become U.S. citizens.
You hear the term, it's often used in a derogatory sense.
derogatory-
anchor baby,
yes.
that's another thing. That's the
Yeah,
term.
because-
That's more in relation to getting the parent citizenship.
Correct.
But it utilizes birthright
Just
citizenship.
status, honestly, not
Yeah.
even necessarily citizenship, because for a long time the United States was very much against separating parents from children. So that if there was a case, we've seen that obviously change under both Trump 1.0 and Trump 2.0. But oftentimes, if you had children who were American citizens because they were born here, and parents were either the status was up in the air, or they were just downright here illegally, they would not be sort of expedited towards deportation because of the fact that it would be breaking up a family or potentially sending a child to a country that they have never lived in and are not a citizen for, right? Sort of like, why would you send someone who is a citizen of this country to a place where they are not a citizen? Aren't you creating an immigration problem there? Regardless, they are saying that it's a modern sort of facet here of the world that we live in now, that there is this industry that is going on. And the Solicitor General brought this up here. And we have this very snarky exchange between he and Chief Justice John Roberts, where he is asked again about this. And we have that on tape during these oral arguments. Let's go ahead and play that exchange.
I think it's, I quote what Justice Scalia said in his Hamdan dissent, where their interpretation has these implications that could not possibly have been approved by the 19th century framers of this amendment. I think that shows that they've made a mess, their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out, to where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Now, if I were a justice, I would be unable to not point out the fact that it would require more than one plane for 8 billion people to come on over.
I'm glad we made that very clear here.
Of all the things that justices and lawyers love to fact check on that, it really does pain me that metaphor is able to be used and nobody corrected him. But there was a correction that was issued by the Chief Justice there. When the Solicitor General replied that it's a new world, Chief Justice John Roberts responded, well, it's a new world. It's the same Constitution.
That harkens back to that originalist point of view, yeah.
Yeah, and so the 14th Amendment, while it is a bit hard to, again, the Constitution can be amended, right? The original Constitution did not include a provision for what to do with the children of immigrants and or slaves. That's why we saw a number of Supreme Court cases and then eventual amendments here on this issue. Regardless, obviously that 14th Amendment was the main defense, if you will, the main point that was used in the decision here today by at least 5 of the justices.
Yep, that's the case. So let's start here with the first justice, the Chief Justice, that being John Roberts here. He wrote the opinion for this case. Just for context's sake, a very heavy, thick opinion. I think it totaled 94 pages. I'm pretty sure this opinion right here that you'll hear and some of the supporting opinions, I think it ran about 24 pages. The dissent ran about 90 or so pages.
The total, I believe, is more than 190 pages for this case. Jokes were aplenty about how it is. They have literal boxes out at the Supreme Court that interns will oftentimes grab, copies, and then they run to the news organizations to get the news out. It's very old school. Love it. The joke was there was 2 boxes put out. How is it that this one case fit in even just one box? Right?
Yeah. 2 news outlets got it, so they had to share it, I guess, because it was so dense. You don't see that all that often with these Supreme Court cases. We remember I'm a physical copy kind of person, so when we talked about the tariff cases, I printed them out, and I was like, I'll print this out. As soon as we looked in, I said, I don't think we have enough paper nor ink in this building to get this case printed out. But
500 pages for the 2 of us.
Exactly. With all that being said, well, it looks like we're smart if we have that on there. It looks like we read it, even though we weren't able to read all of that in that time. But we were able to get some of the highlights of this. We want to show that to some of you right now. Starting off with that Chief Justice John Roberts here, who said, citizenship then and now was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to, quote, every freeborn person in this land. We keep that promise today. We talked about that originalism. He is explaining that in the context of what the framers of the 14th Amendment meant at that time. So when you hear the Solicitor General Sauer talk about it being a new world, talking about all of the different advances in technology, the differences in the way people travel nowadays, how quickly you can travel, how you can, of course, you talk about that birth tourism concept, making those claims about people who are going to other countries, specifically the United States, for the expressed intent of having a child that could be a U.S. citizen. He's saying that, he's not even in this part, and here he's not even contesting the validity of that concept necessarily, because to him it doesn't matter. That's not what the framers meant when they were drafting the 14th Amendment. That's what you're hearing there from Chief Justice John Roberts. That was an opinion that was also supported by Amy Coney Barrett, the liberal bloc of the Supreme Court, that being Kagan, Jackson, Sotomayor. You also saw that from from Roberts. Kavanaugh was technically part of this majority in the fact that he said that he was in favor of striking down the executive order, but I'll let you take it away here. It wasn't for this same reason, so that's why we have that 5.5 to 6.
Well, yeah, because again,
5 to 6.
it's important to know the Supreme Court doesn't keep like an official like scoreboard count, so it does allow for justices to do maneuvers like this.
That's something we often do just to visualize where the court stands on a certain issue.
Yeah, for instance, they also don't have D's and R's next to their name, right? But we parse. They are sometimes liberal, conservative, etc. So essentially, what we are hearing from Justice Brett Kavanaugh is that while he believes that the court order violates the 14th Amendment to the Constitution, he disagrees with the court's. Well, let's pull up the quote right here. The quote is, "The court today holds that the order violates the 14th Amendment to the Constitution. I respectfully disagree with the court's constitutional holding. In my view, the executive order does not violate the 14th Amendment, but the order does contravene a federal statute." So he does not believe that on the basis of the constitutionality of this, that it is a violation. But he does believe that it violates a federal statute. Now, many people are parsing this as sort of throwing a bone to lawmakers to change, to make a congressional change here, to potentially, as again, mostly conservative lawmakers feel, is a broken system when it comes to birthright citizenship. Because respectfully to Justice Kavanaugh, it's not clear if this makes a whole lot of sense in what he's writing. I guess, look, I don't have a law degree, but it's one of those things where it's like this case was on the basis of the 14th Amendment. The arguments were made about whether or not this was a violation of the 14th Amendment. And so if you do not believe that it violates the 14th Amendment, then why not simply just dissent, right? The fact that you're joining both sides, if you will, it just, I don't know. It very much confused me. It still confuses me about the motivation behind this, and maybe that's the problem. I shouldn't be trying to look for a motivation behind this. But it's a rare move, and it is definitely one. I know we saw a little bit of this also with the trans ruling as well too from some of the liberal justices. So it's probably not fair for me
that
to
one,
say
however,
that
was
rare.
two separate lawsuits.
But those were two separate lawsuits,
one
right?
ruling, so they did
Yeah.
that. So this one's
So
a little bit different because this is one case in particular.
This is one case and one fundamental argument. Does the birthright citizenship does this executive order violate the 14th Amendment? And so if you believe that it does, why not just dissent?
Yeah, that's a question that I'm sure people are going to be talking about.
And I'm sure
today.
Brett Kavanaugh will totally answer those questions, right?
Maybe. We saw Amy Coney Barrett be very upfront recently about during her book tour.
Right?
Yeah, she talked about Roe. She talks about affirmative action on that. So I mean, we do often see these Supreme Court justices offer a lens in, pull the curtain back into what goes on. And sometimes you're pleasantly surprised. So, I mean, who knows? That door is always open depending on who it is and whatnot. I want to add on to this quote here. He also said, he specifically says that it's U.S. Code 1401A. We won't describe what that is necessarily because that's not necessarily relevant. But he says in here that Congress could otherwise enact new legislation establishing exceptions to birthright citizenship for children born to foreign citizens unlawfully or temporarily in the country, but Congress has not yet done so. We're going to build off of that quote after we take a break here in just a second and talk about some of the reactions that we're seeing from it. But one thing that I do kind of want to point out too before we just go to a break here really quick is that this is a concept before we even go I'll show you here some of the opinion polling that we see here where a large majority, around 7 in 10 Americans who responded to this did say that they were in favor of birthright citizenship staying in place, that they wanted the Supreme Court to let it be. It was only 27% that said they wanted to reverse the ruling, 4% undecided, no opinion. We'd be remiss if we didn't talk about some of the actual dissent, that being Clarence Thomas, that being Neil Gorsuch, that being Samuel Alito.
There's a very interesting analysis here of the Neil Gorsuch because he had his own dissent. He basically says that he would deny birthright citizenship to children of temporary visitors, but not illegal immigrants who lived here permanently. So on the question, so there was the parsing of visitors, visas. We've brought up the U.S. men's national team soccer player whose parents were
Balogun.
literally visiting. And because she was unable to get on the plane and had to give birth here, he became a citizen. So in that case, Neil Gorsuch would actually say he should not be a citizen, but the children of parents who are here illegally should be considered citizens. And in that case, on just should the parents of should the kids of illegal immigrants be citizens, it's actually more like a 7-2 decision. So that's interesting. That's just some more analysis that I'm seeing as constantly looking at the fees here.
I'm interested. Yeah. I'm glad that you mentioned that, because that is a far more nuanced take.
Very nuanced.
And we like to highlight those. I'm going to read Justice Samuel Alito in the dissenting opinion, whose opinion is more in line with what the traditional conservative viewpoint of this would be. He says, quote, "One of the most important decisions in the history of the court." He called it a serious mistake, but he continues to say, "Careful analysis of the text of the 14th Amendment and the process that led to its adoption shows that it does not degrade the concept of United States citizenship in this way. Instead," he says, that the 14th Amendment confers citizenship on only those children who, at birth, owe allegiance solely to this country. So it's that jurisdiction thereof part of the 14th Amendment that was really kind of the sticking point in these debates there, essentially meaning, what does that mean? Does that mean within the confines of what is known as the borders of the United States? Or is jurisdiction thereof, quote unquote, swearing allegiance to? So if you are a British citizen and you come and visit in the United States, well, that child might, in the traditional sense, be an American, but they're arguing because their parents had sworn allegiance to Britain or whatever it is, that is the true definition of jurisdiction thereof. So, of course, the majority of the court did not support that argument. That was one that we did see Samuel Alito there be in line with. That was something that we saw the Solicitor General argue to the court. Yeah. Very much in line with that traditional viewpoint of those who are traditionally against this concept of birthright citizenship. However, a lot more nuance than I think perhaps either you or I expected, or maybe a good amount of nuance, because we heard those oral arguments, and we caution that what you hear from oral arguments, the tone of the Supreme Court justices, the perceived levels of skepticism towards the questions that they may or may not ask either the challenger or the defendant in a lot of these cases, it's not indicative of what they're going to rule all the time. So if it sounds like they seem poised, that's what you read in the headlines, they seem poised to uphold birthright citizenship. It is not a responsible thing to count that as a slam dunk. Don't count your chickens before they hatch. Correct. Necessarily. Yeah. If you're someone who read that, you're supportive of birthright citizenship. We wanted to caution that because we just saw it change in the mail ballots thing, when we'll get to that in just a little bit with Steve Price joining us. But it seems more like this was the case. Even though it was a 6-3 ruling, we were able to see some of that nuance even within the dissent, and of course within the sort of concurring opinion with Kavanaugh.
It's amazing. And again, this is what obviously the basis of our country is founded upon, is all these co-equal branches of government, the justices, and being able to sort of parse and it not be so black and white sometimes. There is some obviously beauty in that as we get to nerd out on decisions like this.